Welcome to this video on transfer pricing for intangibles. The point of this video is to talk about a method called the comparable uncontrolled transaction method, or commonly referred to as a CUT. Now, we've already talked about in earlier videos what are intangibles, how they might include things such as patents or copyrights or know-how or processes that are sort of trade secrets. All of those issues we've already talked about, but now we want to talk about exactly how one would go about coming up with what a arm's length price would be for a transaction that might be happening between related parties. So let's go through some of these details. A comparable uncontrolled transaction, or CUP method. Now, in the US regulations, this is going to show up in a section called 482-4, which is that section of the code that talks about pricing intangibles for related party transactions. And it's also in the OECD guidelines. However, in the OECD guidelines, they don't use the term CUT, they use the term CUP. So it's a minor difference. They do not create different names for methods as to whether they're for tangible goods or intangible goods. And the key issue of a comparable uncontrolled transaction, then much like a CUP, which you may have studied for tangible goods, is we're going to look at the amount charged for a controlled transfer of intangible property, controlled meaning between related parties, and whether that's arm's length by referencing it to the amount charged in a comparable uncontrolled transaction. So a situation in which the two parties who are transferring the intangible are not related to each other or are not economically controlled by each other. So in that way, it's very similar to some of the things we've talked about in the past, probably with regards to CUPs. But essentially the challenge is, of course, is to find that transaction. Now, critical to having an analysis that's going to be reliable is going to be how similar is the intangible that you're using as a reference point to the one that you're actually transferring. How similar are the circumstances associated with that use of that intangible? That's going to have a great degree of impact on the comparability. So we're going to talk through a lot of the details as far as that goes as to some of the things that might be involved in that. So the CUT method. We're going to have a controlled and an uncontrolled transactions involving either the same intellectual property or highly comparable or very comparable intellectual property. So IP is just a short form for the term intellectual property. And as I mentioned before, you can find this in 482-4 for details. So the intellectual property involved in both the controlled and the uncontrolled transactions it's got to be used in connection with similar products or processes within the same general industry or market. Otherwise, it wouldn't be very comparable. As an add-on point, it should have a similar profit potential. Now, if you look at the US regs, they've got some very interesting examples that you can go through that talk about licensing, say, a pharmaceutical product, a drug, that the related party is licensing it to another related party in one country, and then in another country it's licensing it to a unrelated party. And you say, what are the similarities in these two transactions? Do they reach the level that one could use it as a CUT? And they point out that in this particular example, which is a hypothetical one in the regulations, that the two countries that they're licensing to are similar in size economically. They are similar in income per capita. There's the incidence of the disease that this drug would address is relatively the same in both jurisdictions, and therefore you could conclude that they probably have similar profit potential. And because they also meet all the other aspects of the comparabilities that might be considered, say, for duration or rights to updates or sharing of the product liability risks or any of those issues that come up, all of those match up, and therefore that example in the regulations conclude that this would be a reliable, comparable, uncontrolled transaction, then a reliable analysis based upon a CUT. So to give you an example of this similar industry, etc., one of the things I want to point out is a real-world case that you can find agreements where Harvard University has licensed the rights to use the name Harvard and their logos and other things to unrelated parties. And I'd say, wow, that's really interesting. Now, what's critical here to keep in mind here is the usage. Harvard agrees to license its name and logos and other trademarks to firms that are producing apparel where they want to put the Harvard name or logo on a t-shirt or a hoodie or some other product that then they're going to sell and or Harvard might sell in their own bookstore and such. So you'd say, okay, that is a uncontrolled transactions for licensing of the use of the name. Now, if Harvard were to be licensing its name to, say, a related party for opening up an extension of Harvard University in, say, Tokyo, and for some reason one needed to put an arm's length price on that, you couldn't use the transaction that Harvard University has with the uncontrolled party who's making the t-shirts. Yes, it is the exact same name and logo, but it is a much different profit potential. And therefore, it just wouldn't be a reliable, comparable, and controlled transaction for the purposes of, say, licensing the name Harvard if you were going to use it for an academic institution, say, Harvard Preparatory School. It would have a much different value proposition. So it wouldn't be a reliable comparable. So let's talk about the core comparability factors. Now, in all the regs, when you mention these core comparability factors, these same 5 terms keep coming up in the US regulations, saying every single method, these 5 terms matter. However, they matter in different ways depending upon the nature of the transaction. So when it comes to intangibles, if you read that section of the regs, you'll see a greater description of how each one of these terms, may come into play. So, for example, comparability factors specific to intangibles, a similar product or processes within the same general industry or market. For example, you may have noticed recently a lot of advertising in the last few years with regards to new drug treatments for the condition of psoriasis. And I'll start reading, you probably know them by their brand names given the amount of advertising, but Humira, Enbrel, Taltz, Stelara, Otezla, all of these drugs are out there. They're all addressing the same condition, psoriasis. And so that's going to create an issue of saying these would be essentially potentially comparable to each other. Now, each one might have some differences, and therefore you might need to make some adjustments. Some of them might have different, say, for example, side effects. Some might require different dosages. Some might be delivered differently, injections versus tablets, etc. All those things might come into play. But it's feasible to think about these as being within the same products for the same general purpose in the same industry or market. So it would meet that level of comparability. Similar profit potential. Well, it's basically would come down to what would people pay to get relief from the condition of psoriasis. That would tell you what your profit potential is. It's going to have interesting issues depending upon the insurance behind these, how much one has to pay out of copays, etc. But if we're talking within the U.S. marketplace, this is probably roughly the same. If you're going cross borders, you might have a much different situation in which you might say, oh, the UK or Canada has a more nationalized healthcare system, in which case you may see a much different kind of pricing for the product and therefore a different profit potential. The terms and the durations for the transfer, well, of course, the duration may be quite important. If you're licensing something that like a software, you may need to know that you're going to license it for the entire life of when you'll need the software so that you don't end up in a situation where you don't have the software you need to make your process work. Terms can be quite different also. Say, for example, with software, one could license software with the rights to use the code versus licensing that software with the rights to take the code and then after modify it and use it in some modified way. So, for example, when you license your software from Microsoft, say the Microsoft Office suite, you're just licensing the right to use it. You don't have the right to go in and look at the source code and then start taking pieces of that source code and using it in new and interesting ways. Your license was simply to use. The stage of development can make a huge difference in the value of an intangible. So just to give you an example, imagine that if you're comparing a drug that has already passed human clinical trials and is on the verge of being approved by the FDA for use in the general population, that is not at all comparable to a drug that might address the same condition and the same problems and such, but has only now passed, say, the initial animal trials and has not been taken to the level of, say, human clinical trials. So because they're at much different stages of their development, they would have a different value and therefore merit a different royalty. Something like the rights to updates, revisions, or modifications. Right? If you're licensing software and you've licensed version 1.0, it's going to make a big difference to you when you sign that license if you automatically get the right to update to version 2.0 when it comes out, or at least update at some fee, as opposed to not having that right, and therefore when version 2.0 comes out, you have to pay for it all over again. That would impact tremendously on how much you're willing to pay for the first version. And it's important to keep those in mind. Economic and product liability risks. If you're licensing, say, a pharmaceutical, and there ends up being a problem because the side effect is quite bad and people start suing over the uses of it, then who has to bear that risk? Is it clear that when you licensed it, whether you bore any of that risk or whether you were going to be indemnified by the producer of the drug who says, here, you've got the rights to create the drug and use it, but so long as it's the exact compound we've licensed to you, we bear the risk if there's a lawsuit involved in it. That would be very important. The existence of any collateral transactions or ongoing business relationships. This happens a lot with our clients, is that the intangible might be just part of a package where I not only license the intangible from you, but I'm also purchasing components that I'm assembling into a final product, in which case there are related transactions that go along together. And that may be quite important to consider when you're looking at a comparable. Does it also have that same combination of transactions? Or in some cases, we may say you may need to look at this on a more aggregated basis. Do we need to look at both transactions at once? Sort of thing. And other services included. So for example, if I'm comparing a license to software, is there an add-on service that's included in that license? Say, for example, I not only get the software, but I get a help desk that is going to answer my questions as they come up. That value of that would be different than the value of the software alone. And so that's a condition that one wants to think about when you're looking at comparing two transactions. Did I license the intangible? Were there any other services added on together with this intangible? Say, for example, not just, say, the drawings to the design of something, but also access to the engineers to help modify it or explain it as need be to make it work in my process. That would be an add-on value. I would pay a higher royalty if the intangible comes with those kind of services added on. So we're going to talk about two different types of cuts, one being internal, and you can guess the next slide is going to be about external. But an internal cut happens when the related parties that are licensing the intangibles have a contract with an unrelated party that's comparable in terms and conditions. And therefore, I can look at the pricing between the taxpayer in this diagram and the unrelated party, the lower half of that chain, and say, if that transaction is comparable, I could use the price on that to establish what would be the arm's length price to be used when the taxpayer is licensing it to the related party in the upper half of that chain of transactions. And again, I'd want to take into account all of those terms about comparability and either control for them or make some adjustment for them if I can't control for them. This is essentially a world in which you can get a very reliable comparable and controlled transaction and have a very reliable analysis. However, it doesn't exist all that frequently in the real world. Taxpayers often are licensing intangibles to related parties, and they want to control the access to that intangible as part of either, sometimes it's trade secrets, it's a competitive advantage. They don't want to license it to any outside party to use it. In particular, not to someone who might be doing it directly in competition with themselves. So We don't really observe this fact pattern all that frequently. But it does happen. And when you're doing your interviews and considering using the cut method, you need to ask all the questions to find out whether this intangible that you're looking to do an analysis of has been licensed to anyone in any format that might be seen as comparable or similar, so that you can consider whether this is the best cut you could get. But often we don't observe a taxpayer that's licensing it to a related party. We're working with taxpayers who license to related parties, but we often don't see is the taxpayer licensing it to a unrelated party to come up with a pricing approach. So we do observe situations in which an unrelated party is going to license intangible property to another unrelated party. And when they do that, we're going to be able to observe potentially a comparable transaction to what we're doing. Now, it won't in all likelihood be identical, but it may be sufficiently comparable that we can use it as a good reference point. We'll consider all of those comparability factors we've mentioned in the previous slides, but then we will look at this and say, does it meet the standard of comparability? Hopefully we might find a dozen of these. And we will, in all likelihood, use an interquartile range of what we've observed to say here is the range of arm's length prices for a comparable intangible. We're going to use that to establish what the price should be between the taxpayer and its related party. Now, where would we find data like that? Well, it comes from a variety of places. In particular, we license and use, in particular, KT Mine and Intangible Spring. These are all names of databases that KPMG has licenses for. Some of the other places, though, that you may see people using would be Royalty Source or Royalty Stat. LexisNexis is a large database of legal documents, articles, publications, etc. You can often in LexisNexis find that agreements have been disclosed either as part of a 10-K filing with the SEC, sometimes as part of court proceedings. There may be some trade papers and publications that have information on these. Sometimes people use franchise agreement sources. So if you're franchising out the rights to, say, set up a retail food establishment, that comes with the rights to use brand name, trademarks, etc., plus also a business process. Those might be reasonable, comparable transactions for what you're doing with between your taxpayer and the related party. So there are different places one can look to for the franchising agreements: bond franchise, world franchising. There may also be internal data that you could use, license agreements between the client, who's the taxpayer, and unrelated parties. Again, this is always keep tabs on whether there might be an internal comparable and controlled transaction that you could use as a reference point for pricing the controlled transaction between the taxpayer and the related party. So that concludes our presentation on the initial view of cuts. I hope you've enjoyed this video, and please look forward to the next video in this series.